All right, so hello everyone, and welcome to our colloquy for Springfield for week 1. So this is the second part of our colloquy that we started in Toowoomba. And by colloquy, basically I mean the lectorial or lecture tutorial where we bridge the content that you should have actually been already looking at as part of the lecture recordings online. And we're going to link that to what we have in relation to tutorials. I'll take you just quickly through lecture 0 again. So this lecture is of course recorded and available for you online already, but just to emphasize a few things. I'm your primary point of contact. I'm going to be your examiner for this course, so it means that I'm going to be the one who's going to be setting your final exam, and I'm going to be the one who's going to supervise the marking of your assessments, including the assignment and the exams. I can be reached on this email. You can also phone me on this phone number only for urgent matters. And there will be some office hours both here in Springfield as well as in Toowoomba, and always by appointment. Okay. You can also get help on academic matters on the first email here. And if you have some problems with ICT, you can also contact USQ support. Now, here's the contract we're going to have with each other in order, hopefully, to not be able to ever see you again doing this course. So, to pass this course, I want to make sure that you have an aggregate of 50 marks. What does that mean? It means that you don't have actually to pass any part of the assessment, but cumulatively, you need to get at least 50 marks. You can fail, for example, the final exam and still pass this course. Okay? The easy marks will come from the quizzes. You have 20 marks on the first quiz. You have 10 marks on the second quiz, which we will talk more about in a minute. And you have 20 marks on the assignment, right? So that's 50 marks. And then you have another 50 marks on the final exam. Part A of the final exam is going to be multiple choice questions, 15 questions worth 15 marks. And then the hardest part really is the second part of your exam, which is your part B of the exam, which will be problem-solving questions. Is this clear? Any questions on what you need to do to pass this course? Now, this is an introduction to law. How many of you are engineering students? Engineering students? No? Human services? All business? Okay. So, you're not really required to become lawyers, right? This is simply to show you how law would impact you as a manager or someone who's working in a business environment. Okay? So it's going to be at an introductory basic level, but you go back and look at the specs for this course, you'll find that you are still required to have at least a minimum understanding of critical skills and a minimum understanding of legal analysis. And that's the part that we will expose more when we talk about the assignment as well as part B of the final exam. Now, this is, of course, your assessment schedule that's available on StudyDesk. I got a confirmation today. I have very low level of tolerance when it comes to what happens in my lecture classes. So, as I said again, you don't have to be here. And I didn't say that just to be funny. You don't have to be here if you have something better to do. Everything is being recorded for you, so you can look at the recording or even join us live on Zoom. You don't have to be here again, okay? And I can now tell you that you don't even have to be here for the tutorials. I just got a confirmation this morning that the changes to the specs that I've discussed with the people in Toowoomba has now been approved, which means the following. Everyone will have to do the second online test. You are not going to get any marks for tutorials anymore. So you can come and listen to tutorials, or you can listen to tutorials online, but there will be no marks. Okay? This is just for you to understand better and hopefully to get a better mark on the final exam. You have to do the second online test regardless of whether you are on campus or online. Is that clear? So what it says here in lieu of tutorials is not true anymore. Okay? That is not true anymore. Everyone is going to have to do the quizzes, the first one and the second one. Now, this is good news, by the way, because it's easier for you to do these tests. They are very simple. So if you really want to pass the exam, if you want to pass this course, I expect you to ace these quizzes. So you can get 20 out of 20 on the first test, 10 out of 10 on the second test. You will fail your final exam, and you'll still get a C, even though you got 20 out of 20 and 10 out of 10, because that's the part that we call legal knowledge. That's the really easy part. So that's where you need to capture those marks for the 50 marks you need to pass this course. Okay? Usually the average is around 17, 18 on the first test, and around 7 or 8, maybe even 9 on the second test. So if you don't do well on these tests, you know what's going to happen to you. So how do you do well on these tests? We said that all of these assessments are already open for you. This is what we call part of this idea of heutagogy. So the idea that we want to make sure that you have as much time as possible to do these quizzes. So if you go to your assessment tab, and we just scroll down a little bit, you'll find that there are these ticks, these boxes with ticks, like this one up there. That's where you can access your online quizzes as well as the scenarios for your assignment. Let's talk about the quiz just quickly. So we can see already that there are 16 people who have gone inside and attempted, in the sense that they have printed off or saved their questions. So you want to come to this screen, to this page, and then simply view for printing, and right click and print your 20 questions. Okay? The key point is that you start answering these questions, so print these off and just put them next to your desk or wherever, and as you read, let your reading be guided by both the learning objectives for each chapter and these questions. So read the questions before you go and read the chapter. So when you are reading the chapter, you're looking for something. Okay? I really hope that you will all ace these. Okay? The same thing for the second online test. Please do so this week. Go ahead and print off these and keep looking at them as we go through the lectures, the lectorials, or the colloquies and the tutorials. Now, the same thing for your assignment. Of course, next week we will really go through the assignment in much more detail, but you can see here that you have the documents required for the assignment, where you have the written assignment details, the template for the written assignment. So this is the file you need in order to put your answers into that template, and that's the one that you will upload online. Don't worry about submitting anything to Turnitin. It will be done for you automatically. So there will be something that comes up on the screen. You just accept, and then your assignment is going to go to Turnitin. Don't worry about the percentage of similarity, because it really depends on where that similarity is coming from. It could be 100 out of 100, 100% similarity, but you still don't have any plagiarism. So it depends where it comes from, all right? Don't worry about that too much. So you need 2 scenarios for your assignment. And you go down, online test, written assignment. Again, there is this box with a tick. So you click on that. And 22 attempts already. You preview the quiz. And you will come to this screen where you have your question 1 and question 2. Basically, that's your scenario 1 and scenario 2. Don't worry about this white box underneath. That's not relevant to the assignment. All you need to do now is to simply copy and paste your scenarios into the template, the file, the Word file that you have. Just cut and paste. And that's where you're going to write 400 words on each one of these. Next week, we're going to look at how you analyze these using the methods we will talk about as well today. All right. So any questions about assessments? Yes?
So what you're really saying, we can download and print off the actual assessment?
Yes?
But that actually, it's not like a once in and then if the assessment closes, so we then just go in later on before the due by date and put our answers in?
Correct. So you don't submit until you have answered all the questions, right? You submit at the end. As long as you don't submit, you can go in and out as many times as you want. You can answer the questions one at a time, for example, and save that and go out again and come back in. All right? All right. Any other questions? All right. Let's then talk about the My Opinion survey. From the feedback we got from the last cohort, so from 2016, we went back to the faculty and told them that we would like to do these things as far as the specs are concerned. So that was the first one, that we wanted to standardize all the assessments, regardless of whether you are online or on campus. And the second thing that we were able to get approval for was the idea of an open book exam. So we are very lucky, because this is going to be the first semester where we're going to transition from a closed book exam to an open book exam. So for the first time, you don't really need to memorize anything. Okay? You don't need to memorize, but you need to summarize. What does that mean? You still have 2 hours. You still have the same exam format. But now, in order for you, for example, to use the ILAC method, which is the issues, the law, the application, the conclusion, I don't want you to memorize the law. Instead, you are going to be able to bring in your textbook. You're going to be able to bring in the tutorial questions and the tutorial answers, slides, and your own notes. Okay? And that's what you are going to use in order for you to answer the question or questions that will be in part B of the final exam. In previous semesters, we used to give students the Part A multiple choice questions, which means that you used to get those before the exam, and then you can look at them and attempt them before the exam, and then when you come to the exam, you're ready to answer the questions. This time around, of course, you will have an open book exam, so there's no reason for us to give you these questions in advance. But I'll still think about the possibility of doing that, but with a smaller time window. So instead of giving you these 2 or 3 weeks in advance, it might be maybe just 72 hours before the exam. But I still think that because you have an open book exam, you don't need that. The questions are basically very similar to what you have in your tutorials. But we will talk about that in much more detail later on. So the good news is going to be an open book exam. You don't have to memorize anything for this course. Now, we said there's an easy part. We said there's an easy part to this course, which is your legal knowledge. And you can get the legal knowledge from your textbook. Okay? So this is simply about the history of our legal system, the different legal methods that we will be discussing, or theories rather, and how to apply them and so on. Summaries of case law, some information about some statutes, but that's really the simple part. Now you don't have to memorize any of that stuff. You just need to make sure that you have useful summaries for the exam. But for legal reasoning skills, and these will be required for your assignment and for Part B of the final exam, we have to go through some more structured analytical frameworks. So the first one is known as Wentworth-Miller, and the second one is known as ILAC. There will also be things in relation to statutory interpretation, and most importantly, the ability to be critical in analyzing what you read and what you propose, the arguments that you make. So we spend most of our work in the colloquies and the tutorials working on this part of the course, not the legal knowledge, which you already see in the lecture recordings online. We want to really focus on this difficult part because that's not in your textbook, that's not anywhere else. So this is the latest version of the textbook. Some people ask, do I need to buy the textbook? And as you realize, hopefully by the end of this course, there's only one answer to that question, and that would be what? It depends. Okay? From now on, we're not going to answer things by yes or no, because there's no black and white anymore. It always depends. It depends on you. It depends on how good you are as a student. It depends on your needs, on your learning approach. Some people like to read. Some people like to see. Some people like to listen. So if you don't want to buy it, I think that's fine. Just go through the first few weeks and see if you really still need that or not. Okay? As we said, most important thing is to print off your quiz questions and the assessment, the assignment scenarios, and then take it from there, if you still think that you need it or not. Now, some of you prefer to buy older versions. So, okay, let's look at this. If you buy the latest edition, then you will be able to also access what's available for you online from the publisher, from Pearson, and you will need the course ID here. Okay? So you need a course ID, and the course ID is Gussen, G-U-S-S-E-N, 49907. Okay? You will need this course ID if you have the latest edition and you want to also use what's available online. Milo Lab, they call it. So if you find earlier editions, that's also fine. You find the compiled versions from previous years, 2013, I think, that's also fine. Don't worry too much about whether you have the latest edition or not. Okay. Let's see then what you need to do in order for you to succeed, in particular in this learning, in this legal skills part. Okay? So this is not legal knowledge. This is the legal skills part, which is 45 marks. So 20 marks in the assignment, and then 35 marks in part B of the exam. So you need to be able to identify what we call legal issues. And what do we mean by a legal issue? Can someone give us some ideas of what is an issue? Where do issues come from?
There's a deviation in a contract.
So one example is the situation where you have a contract and there's a deviation from the contract that gives rise to this idea of issues. But why is it an issue? The deviation you talk about, why is it an issue?
Because there was agreement between two parties.
There is what? Disagreement, right? I'm heavy on hearing, so you need really to project for me.
Okay, there was originally an agreement between two parties.
There was originally an agreement between the two parties, and then what happened?
Yep, so one breached one of the contract rules.
There was a breach of the contract. Yes, okay. So can you give me another word for issue? In this situation, when there's this divergence from the original contract, what has that created? Problem, conflict. Okay, these are other synonyms for the idea of an issue. So there's tension. Okay, there's tension between two parties or more. One party wants something, the other party wants something else. One party is arguing something, the other party is arguing something else. That's what we call a legal issue. It's like chopsticks. See, there was a book called Getting to Maybe, which was a very favorite of mine when I was doing my legal studies. And it always shows you this bifurcation. So on the cover, you will find that they have something like a bifurcation. You know what a bifurcation is? So it's something like this. You can think of them as two chopsticks. And the idea is, where do you go? So what we just did was basically to look at just two chopsticks. Okay, we're there already. So it's something like this. Okay? It's a bifurcation in the sense that you could go in one direction or the other direction. So if you go in one direction, one of the parties is going to win. If they go to court, for example. And if you go to the other direction, the other party is going to win. Okay? That's why we call it a tension. So how do you decide which one of these paths or roads is the more acceptable or the most probable if you go and take this action to court. Okay? So, have you heard of something called game theory? Have you done game theory already? If you haven't, it's pretty much like game theory in the sense that you do something called backward induction. So you look at these facts and try to ascertain which one of these paths is more probable, and you build backwards. So then you can take the decision whether you want to sue or not, or whether, for example, you want to go to something like alternative dispute resolution, or whatever strategy you want to use. Okay? So this is what we want to really introduce you to, but just only at really a basic level. Okay? So that's what we mean by a legal issue. When we mark your final exam and when we mark your assignment, it's really these legal issues that we are looking for. So it's called spotting the legal issue. Okay? Once you have spotted the legal issue, then you can decide, how you're going to argue it using the law that you know about that area. One area, for example, could be contracts. Another area we're going to talk about is torts. Yet another area is agency, okay, or even some criminal law. The key point here is that this course is again for business students, but we are using this teaching philosophy that we call heutagogy, in the sense that I'm not here to teach you the content of the legal system of this country, because I cannot teach it to you, not even in 4 or 5 years. You want to do that, you can go and get yourself a JD or an LLB. What I'm teaching you here is how to learn on your own about the legal system. So, if you graduate and you end up looking at something that has to do with employment law, you would be able to analyze the problem you're looking at without me being there telling you what the content of employment law is. You would be able to identify the legal issues and give a coherent recommendation to your management or to your business as to whether you want to pursue this in court or not. Or even before it gets there, if you are presented with situations where you have to review contracts, for example, procurement contracts, for example, you are able to spot any issues that could be in the contract. So you'd say, no, I want this to be changed to this. So that's the idea behind this course. So you have to be able to apply the legal area, and you need to know where to find the information. This is much easier, of course, if you have the textbook, you have your summaries, and of course for the assignment, there's only one area, which is the alternative dispute resolution area. So that's much easier, but builds towards the final exam. Now, then you have to identify something called elements. And on Monday, we talked about elements in Toowoomba, and we said that every legal theory has elements. So for example, has anyone heard about something called the tort of negligence? The tort of negligence has 3 elements. Okay, we haven't studied that yet. On Monday, we talked about the legal definition of the law system, or the legal system, or what is law, and we looked at it in the sense of 4 elements. My point is, every legal theory has elements. And it's your job, once you look at the facts, to ascertain which one of these elements represents a legal issue. Not every element is going to give you a tension between the parties. So, for example, in negligence, which we will look at in much more detail later on, you'll find that there are 3 elements. The first is the existence of a duty of care. The second is a breach of that duty. And the third is a causation element, meaning that there were, in fact, damages, in the sense that there was damage, i.e. injury, whether it's physical or economic, and it was actually caused by the defendant or the other party. But you will find that there are certain relationships between the parties that establish the existence of a duty of care without having you standing there and arguing that there is a duty of care or not. So, for example, if you find a relationship between a customer and a manufacturer, then you already know that there is a duty of care on the manufacturer towards the customer. So that element is not going to present you with any issues. So simply say, we already have precedents that talk about this particular type of relationship, and we already know that the courts say that there is a duty of care. Okay? What is a precedent? Can someone give me an idea of what we mean by precedent? So this is a colloquy, right? It's not a lecture. If you want to look at a lecture, you can just go and listen to the lecture recording that we have online. It's not a lecture. It's a colloquy. Meaning what? Meaning it's based on discussion. Okay? We want to test your understanding, and make sure maybe we can move that further up and improve on that understanding. So I will start picking on people, all right? Just to ask you to maybe contribute whatever you know. Don't feel pressured. If you don't know, just say, I don't know, and we'll move on to someone else. Okay? We'll start with the gentleman here. What's your name?
James.
James. What do we mean when we say that in negligence, some of the relationships, okay, are established categories on the existence of the duty of care? So I said that's based on precedents. What do I mean by that?
I guess there's something like, say, someone's in charge of supervising an area. It's kind of implied that they have a duty of care to look after someone.
Okay, but there's a technical meaning. The gentleman behind you, what do I mean by precedent?
Someone about that care about the duty.
Care about? Okay, the gentleman next to you, what is a precedent?
According to my definition, I think precedent is the head of the state.
It is?
Head of the state.
I can't understand that.
Head of the state. Head of nation or country.
It is a duty of the state? Something like that? Not quite. The gentleman next to you doesn't know. Gentleman, the lady next to you? Okay. Precedent. 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 What is a precedent? Okay. Precedent, anyone?
Something that's happened before.
Something that happened before, but where? There's a gentleman there that's volunteering to give us an answer. Yes, sir.
Precedents where the case has already been argued in court and has been affirmed that if these conditions are applied, then this is the result and it's been, the precedent works on the way up on your hierarchy of.
Okay, thank you. So when we say precedent, we're basically talking about something that happened in the court system that's relevant to where you are arguing this cause of action. So for example, if you bring this action in the federal court system, we have two systems in Australia, right? You have the state court system, and you have the federal court system. Which one is relevant depends on the topic you are arguing, the area of law that you are arguing. Sometimes it also depends, if you want to move up the hierarchy, on how much in terms of damages or monetary compensation you're going for. Okay? The more money you want, you have to go higher. Okay? So, precedent means if you are, say, in the Supreme Court, where is the Supreme Court? Is it part of the state hierarchy or the federal hierarchy?
Federal?
No?
No?
State. So we have the Supreme Court of Queensland. Okay? Okay? So let's say you are arguing your case in the Supreme Court of Queensland. Okay? Now the court, so you are the counsel, and you see that the facts that you're looking at are similar to something that happened in the past. Okay? So you can bring what we call the ratio decidendi, i.e. the reasoning of that court in the previous case, and use it as a starting point for your arguments. Okay? So you would say, based on this case, which would be a binding precedent because it's in the same hierarchy, and not only the same hierarchy, but it comes from a court of law that is actually higher in that hierarchy, for example, the High Court of Australia, because both of these hierarchies end together with the HCA. We'll look at it in some more detail soon. But you would say this case was decided by the High Court of Australia. The High Court of Australia is the last court of appeal to this hierarchy, which is the State of Queensland court hierarchy. So after the Supreme Court, if there's an appeal, it has to go to the HCA. Okay? And that's where it stops. There's nothing after that. Okay?
Right?
Sorry?
That's the Commonwealth, right?
Sorry?
That's the Commonwealth, right?
That's the Commonwealth.
The legal system that's under that, right?
So all I'm saying is that if you want to appeal from the Supreme Court, you would go to the High Court of Australia, right? And if you are arguing the Supreme Court, then you would bring this case and say, this is a precedent, and it's a binding precedent, and it will only be binding if you are in the same hierarchy and the facts are similar. So the other party, the other counsel, could actually argue that the facts are different, and they are materially different enough so that you don't have to follow this precedent. Okay, so we'll talk more about these things, but my point here is this. You need to prepare, please. So there's a reason why you have all of those recordings already on study desk. You go to useful links, you'll find all the recordings for all the chapters that we'll be covering. Because I expect you to go and have a look at these, or read the book at least, or look at the slides before we come to our discussions, please. Like some of you have done, but it seems that it is the anomaly rather than the usual modus operandi yet. Okay. So we have Kimberly that joined us online. Hi, Kimberly. And look, if you have anything that you want to add, maybe you can just unmute your phone and join us as well. Okay, I'll leave that to you then to decide if you want to say something to join us. Just wave a hand for me so I could see that you want to say something. All right. So today we're going to continue on chapter 2 from the Toowoomba Colloquy, and we will finish off on chapter 3. As usual, we'll have 50 minutes, and then we'll break, and then another 50 minutes, and then we'll go to the tutorial, and that would be our last 50 minutes from 3 to 4. Today we're going to zero in more on some examples that you have in chapter 2 in relation to case law. Okay? So let's start with looking at one of the more iconic cases, which is Mabo. And let's start we're just trying to bring up your e-textbook. Okay. So you find us online or later on in the recordings, we're going to Mabo on page 23. So if you have your textbook as well with you, you can follow us on the textbook. Okay. So this is a court that was decided in the High Court of Australia in 1992. Why do you think most of the cases that we look at in your textbook, and for that matter throughout any LLB or JD program, come from these what we call superior courts? Why do we always look at things from the High Court of Australia rather than a magistrate's court, for example? Anyone can give us an explanation to that? Because of precedent. So precedents are set by superior courts, right? So they influence every court underneath it. If it's inferior, like magistrates, it's not going to actually influence any other courts. And you can also add that because these higher or superior courts have more of their judgments reported. Remember, there's also an economic aspect to the law, so we can't actually report everything. Although now, of course, because of these electronic, the ability to record things electronically, so e-government and e-courts, you're able actually to see more being reported. Okay? Again, because it's cheaper. But mostly the reports come from these higher courts. Okay. Now you can see that's called Mabo. How do you read this case? What's the name of this case? Well, yeah, some people would say Mabo versus Queensland. Okay. Mostly you would say Mabo and Queensland because this is really a civil case. And sometimes you'll find the fashionable guys would say even Mabo v Queensland. That's fine. Number 2. Why is it number 2? Does that mean that there's a number 1? Yeah. And then you have something between brackets saying it's 1992, and then it says the HCA. Okay? Now there's a section in your textbook that tells you why it is brackets, not parentheses, and what it means to say HCA rather than to put something like one of the law reports. We'll leave that for you to look at. Why does the name Mabo come first and Queensland second? Could it be Queensland and Mabo?
Yes.
So why did we start with Mabo? Because they are the movement. They are the ones that started the action. So they went to the court and want to sue, okay, the government of Queensland. It could be the other way around, right? And if you, of course, fail on this action and decide to go to appeal, you don't decide really. It's the court that will give you leave to appeal because it's always going to be a point on law, not a point on fact. Then you'll find that they switch. If Mabo, for example, loses this cause, loses this plea, loses at the HCA, let's say it's a lower court, and they lose there, then it will still be Mabo and Queensland in the higher court. Because they would be the, what do we call them? Appellant, and the other guy is called the respondent. All right, let's look at quickly at the facts of this case. So we've just celebrated 25 years of Mabo, of course, but I just want to go through it from a critical perspective. And it's going to be, again, at a very basic level. So basically, in the 1980s, Eddie Mabo, which is part of what is known as the Mary Islanders and Torres, in the Torres Strait Mary Islanders community or peoples. So they're part of our First Peoples or our indigenous people. They decided that the area that they were occupying for millennia, in fact, belonged to them. Okay? So they wanted to have a sort of ownership over that land. Okay? So as it says here, claiming ownership of most of the land of the Mary Islands in the Torres Strait. So they brought this motion against the government of Queensland in the HCA because it is really the HCA jurisdiction to hear such issues between the states and residents, especially if they are not part of that state. So I'm hinting to section 75 of our Constitution. So what did the Queensland government do? Okay? In response to this challenge, they passed what's known as the Queensland Coast Islands Declaratory Act in 1985. Note that this was 3 years after these people decided to move this action. And that's not unheard of. So you'll find that the legal system is very slow, and you have to be really with deep pockets in order to survive to the very end. Some lawyers would actually charge you north of $500 per hour to move stuff like this in the High Court, especially barristers. Okay, so Mabo challenges the government of this state. The government passes in response this act. What does the act say? It says, even if you have ownership rights in this area, the Murray Islands, it has been extinguished. And native title rights claimed to exist in these islands were annexed to the Crown, by the Crown rather, to Queensland. So what are they saying? They're saying, even if you have rights, we have the right, ownership rights, we have the right to extinguish those rights. Do you follow so far? Is there an issue already? Can you see a conflict? Can you see the tension? How do you resolve this tension? One party is saying, I have ownership over these islands. The other party is saying, I've extinguished any rights you have over these islands. So that's when we go to the first case, which is known as Mabo number 1. This is in 1988, 6 years after Mabo started this motion. What was the subject of this Mabo number 1? Well, Mabo said, I'm going to challenge this act that the Queensland government passed. And how are you going to challenge it? See, you can't just go to court and say, I just challenge it because I don't like it, because I think I have ownership rights. You have to use a legal theory. What is the legal theory that they have used? Well, they went and said, this act contravenes, or violates, our Constitution. In what way? So they came with a third piece of legislation. So first of all, we have this declaratory act. And then Mabo and number 1 brought this act of racial discrimination. This is a racial discrimination act passed by the Commonwealth. That's why you have CTH, and it was passed in 1975. So Mabo said, this act that the Queensland government passed, so it's a state act, is in violation of this Commonwealth Act. Why is it in violation of the Commonwealth Act? Because it discriminates against Aboriginal people. And we are Aboriginal people. So if you have an act that's from the Commonwealth, and you have an act that's from a state, and the declaratory act from the state is repugnant in a way to some parts of this Commonwealth Act, then under Section 109 of the Constitution, which one is going to trump? Which one is going to apply? Which one is going to win?
Commonwealth?
The Commonwealth Act. So Mabo simply was saying, your act is in violation of this Section 109. You can't come and say, that all Aboriginal people's rights have been extinguished and discriminate against us as a group. And the High Court agreed with them. And why did they agree with them? So that's something we will leave for now. But once they have agreed with them, then the Queensland government cannot rely on the act that they passed themselves. So we go back now to what? We go back to Mabo number 2. And the original argument that we, the Murray Island people, have ownership rights over these islands. Now, when you argue, I'm not talking about domestic arguments. I'm talking about when you argue in a legal sense. What do you argue about? Do you argue about the law, or do you argue about the facts? Anyone? The law? So let's be very clear, because this is still week one. Let's be very clear about what you argue about. The law, what do we argue about, folks? When you argue about something, why? Why would you argue about it? Because what? Difference of opinion. Do you think that there's that much difference of opinion about the black letter of the law? Most people will agree on what the law is. I can show you. Maybe we'll disagree about some interpretation, but that's not what we are really arguing about. You will always argue about the facts. That's where the devil is. The devil is in the details. You want to argue that the fact you are presenting is wrong, that you don't have evidence of this fact, that the evidence that you have is not enough. Always argue about the facts. The same in this case. They were arguing now that we have ownership. Okay? How is the court going to decide that? So the legal theory that they have evoked is called native title. Now there's something called the Australian Legal Dictionary, which you'll find available online through our USQ library. And you can go there and look more at these things, or also check the glossary at the end of your textbook, or just Google it. Okay? Native title basically says that there are rights that belong to these First Nations that come from their jurisprudence and that pre-exist any sovereignty or importation of English law to this country. What was the problem for Mabo in order to establish that they have ownership? The problem was something called the principle of terra nullius, which is Latin for empty land. So when in 1788 the first British settlers or English settlers came to Australia, they declared the country to be terra nullius. This actually is something that comes from international law, from the Roman times, but it was also modified by English courts. And it basically says, when we came to Australia, we did not find anyone. It was empty. Of course, that's not what was happening. What was happening is that they found people here, and this is the modification from the English system, but they said, these people are primitive. We don't see anyone like us. Like us in what sense? Like us in their sophistication, in their civilization, in that they have enough complexity in their legal systems that we can recognize them as existing in this land. Why would you want to do that? Why would you want to declare Australia terra nullius? Well, if you do so, then you can bring something else called the doctrine of reception. Which means what? Which means that I can simply say, because this is terra nullius, what legal system is going to apply in this country? Well, for my convenience, the legal system that applied from where I came from. So I can just import the English legal system, and it becomes the genesis or the starting point for the legal system in Australia. Mabo needed to argue that Australia was not a terra nullius, that we were here, and that we had enough sophistication and enough jurisprudence to say that we have ownership rights in our lands. And the court decided, after 200 years of declaring Australia as a terra nullius, that that was wrong. 200 years later. And they opened the door to the possibility that Aboriginal people in Australia can actually have native title to areas they have been occupying continuously, basically for millennia. All right. This is basically a summary of what we see in this case, but I want to throw to you this question at the end. Now, you can see that how we write these summaries is pretty much this idea of ILAC. There's an issue, there's a relevant law, they're applying the law, and then they're giving you a conclusion. So this is really showing you what you need to do when you are presented with a problem-solving question. Okay? I will give you the facts. Your job is to come up with the issue or issues. These are the legal issues. And where do they come from? They come from the native title theory or the terra nullius principle or the adoption doctrine that I was just talking about. All right, let's look at case reflection. It says, do you think that the decision in Mabo has really changed anything for indigenous Australians? Let's just take 1 minute, just maybe 1 or 2 contributions, and we'll take a break. Anyone? Sorry?
Massive.
It has changed them massively? Okay, so how do you think the decision changed them massively?
Well, I know quite a lot of Aboriginals up in the Northern Territory and up in Kakadu and Arnhem Land, and they've got the right to actually allow people onto their land, stop people from coming onto their land, stop miners coming onto their land, and just mining things like happened in Gove.
Why do we think that Mabo wanted to establish that they have ownership over these islands? Because they really wanted simply to stop people from coming and going?
No, they wanted to stop people from taking stuff that wasn't.
Okay, so they wanted to maybe protect the land, act as trustees for the land? Yes?
Protect sacred sites?
Okay, what they want really is to protect sacred sites. Any First Nations or Aboriginal people in the room? Yes? Question or comment?
I was just going to say they wanted recognition.
Thank you. So someone's saying, actually, what they want is recognition. Recognition of what?
What they've been looking after, what they've been treating as their home for so long.
Okay. So they want us to acknowledge them as people that what? That have a trusteeship over this land, that they need to be consulted in how the land is actually used or mined or, put to certain economic benefits. But are you familiar with the Maori? The Maori are the indigenous people in New Zealand. And they went through similar tension between them and the Crown. And of course, in New Zealand, they have a treaty, just like they have, for example, in Canada. And it's called the Treaty of Waitangi. And if you have been following the news, you'll find that that's what the indigenous people in this country are calling for. They want to have a treaty-based approach for this idea of constitutional reconciliation or the constitutional recognition of Aboriginals or First Nations in this country. In New Zealand, you'll find that that treaty, after it also has been declared null and with no legal effects, eventually it brought about economic deals between Maori and the Crown that resulted in companies like, for example, Sealord, which is one of the largest companies that produce things like canned tunas and fish and stuff like that. But my point is, because of those treaties and agreements, Maori have become now an important economic force for New Zealand. Do you think that Mabo was able to bring something similar in Australia? Let's leave that question open for now, and we'll come back and look at a few more cases before we move on and talk about chapter 3. So it is now 1 o'clock, and I will give you your 15 minutes. So come back, please, at 2:15. Thank you. Thank you. All right. So we're going to continue now with the second hour of our colloquy, and we're going to pick up from where we ended last time when we said what was the impact of Mabo on indigenous people. Now just quickly, there was a question again in relation to whether we need to attend this lectorial or this colloquy, or whether we need to attend the tutorials. So as I said, this institution, the University of Southern Queensland, is a blended learning institution. So it means you can be on campus as much as you are online. So you really don't have to be here. Okay? If you want to do things online, that's perfectly fine. You can do it live by joining Zoom, or you can just simply download things from the study desk, or even if you don't want to, you don't have to. The key point is that you need to get those 50 marks by doing your own work, your own adults, and making sure that you understand what's required of you for each assessment through the final exam. All right. Let's go back then to our Mabo discussion and how Mabo affected indigenous people. And the point I was trying to make is that in this case, the High Court of Australia came out and said, actually, we got it wrong. This country was not a terra nullius back in 1788. Okay? Now remember, because we said it was terra nullius back then, we were able to invoke this doctrine of adoption or doctrine of reception. And then we were able to use the English legal system as the starting point for our own legal system in Australia. And of course it evolved later on and it became a separate legal system. But even though the High Court of Australia said that we got it wrong and Australia was not a terra nullius at the time, we cannot go back and say that the doctrine of reception doesn't apply. So that became a historical fact. 200 years of English law in Australia cannot be erased by saying Australia was not a terra nullius. So, regardless of what we say, the fact is that we adopted the English legal system, and it was the beginning for the evolution of our system in Australia. Okay. Now, this case basically said this, that there was a legal right that attaches to a community, so it's a communal right, not an individual right, and attached to these indigenous people, and it said that they would have this right of ownership over land that pre-existed the common law system, the English system that we adopted, that we received in Australia in 1788. So other indigenous people said, great. Is this the only right that pre-existed the English law? Or were there other rights as well? So they challenged one more time in the High Court of Australia. Now it's the Walker case. Not against Queensland, against New South Wales. And they wanted to see whether these indigenous rights that pre-existed the English law would actually extend to things other than just ownership of land. Do we have, for example, rights to have our own criminal law? Or does it have to be that we have to follow the criminal law that applies to the rest of Australia? Okay. So you see where they're going with this. In some countries today, you'll find constitutions that talk about this idea of plurinational society. Not multicultural, plurinational, like in Bolivia, for example, or in Ecuador. And there, of course, indigenous population has a much larger critical mass. So they are like 40% of the population, compared to maybe 3% in Australia. But there, they started saying that yes, you can have your own legal system. You can have your own criminal law. Okay? You can also see some experiments in other countries, especially in the Kanzuk countries, for example, with New Zealand and in Canada. But in this case, the High Court of Australia, said, no, we're going to stop here. You do have this native title right, which predates the existence of the English legal system, but no more. Okay? So in this decision, See, the decision says the New South Wales Parliament has the power to make laws for the peace, welfare and good government of New South Wales in all cases. The Mabou decision didn't suggest that Australian parliaments lacked legislative competence to regulate or affect the rights of Aboriginal people, or that these laws are subject to their acceptance or consent. Because you're indigenous, you can't come and say, I have to accept what you are telling me, because I have my own jurisprudence. I have to apply my own jurisprudence. So the High Court of Australia said no. This was back in 1994. Don't be surprised if by 2054 something else comes through and it will have a very different result. All right, let's look at another case as well. And we will look at the next one on page 36, which is the Wallace case. Go through these a bit more quickly. We'll go through them quickly so that we can go to chapter 3, please, and then we are ready to do our... All right. In Wallace, this was another Section 109 case. So Section 109 comes from our Constitution, the Australian Constitution. And what does that section basically say? So if you look at an act that's Commonwealth Act, and you look at an act that's a State Act, and there is inconsistency between the two acts, which act is going to trump, which act is going to actually overrule the other? It's going to be the Commonwealth Act over the State Act. Okay? That's Section 109. In this case, it was about limiting compensation. So this was basically goods belonging to Wallace, and they were damaged to the amount of $1663. The company admitted liability. Yes, we're liable for these damages, but they cited a state act that put a cap on the amount that they would be required to pay in these damages. So they said, we can't pay $1663, we can pay you only up to $200. Wallace didn't like that. So they filed this motion and they said what? They said this act, yes, there is an act, you're right, which is the Queensland Carriage of Goods by Land, okay, Carriers Liability Act of 1967. But they said this actually contravenes a Commonwealth Act. And back then, that Commonwealth Act was known as the Trade Practices Act of 1974. Today, we know this act as... Okay, I think we need to try to get into this meeting again. So we're continuing with our discussion of these four cases, and we need to go back to Wallace. So they said that there's this tension between the cap given by the State Act and the no limit approach given under this Trade Practices Act. We said that this has been repealed now, and it's called the Competition and Consumer Act of 2010, which is a Commonwealth Act. And that's where we will also be looking at the Australian consumer law when we get to that. Okay. The decision was the Queensland Act, which validly attempted to limit contractual liability for breach of warranty, was inconsistent with the Commonwealth Act. What does that mean? If it's inconsistent, under Section 109, the act that trumps is the Commonwealth Act, which means what? There's no limit to compensation, which means what? You have to pay me the 1663. Okay. Let's then move on quickly to the last one I want to talk about, which is the Kuwata case on page 37. Okay. Again, this was an inconsistency 109 case, but this time around, the idea was that Aboriginal people wanted to obtain a leasehold on a river. Actually, a leasehold on a land close to the Archer River. Now, the Queensland government, okay, represented by the Prime Minister at the time, okay, decided that that is not the case because there's this Commonwealth Act, which is the Racial Discrimination Act of 1975, the same one we talked about previously. But this time around, it's not actually used as a shield, it's used as a sword, in the sense that they are saying this act was valid. Okay? This act that discriminates was valid because now the discrimination is coming through the extension of Section 51, subsection 29 from the Australian Constitution, and that section overrides any acts by states. Again, it's the Section 109 argument that the Commonwealth Act is overriding any state legislation, even though, okay, this section at the time did not envisage necessarily that the Commonwealth would actually legislate in this area. The key point here is that there was tension with something called the International Convention on the Elimination of All Forms of Racial Discrimination. So if you are going to say, we're going to give this leasehold to Aboriginal peoples, but not to the rest, anyone else in Australia, you're discriminating in that sense. So this convention required that no such discrimination would take place. So as you see here, as the Constitution stood, the Commonwealth had not been given exclusive constitutional authority to legislate on racial discrimination in the states. However, the High Court held that when the Commonwealth entered into international obligations on behalf of Australia, because the Commonwealth is the one that's going to enter with things like these conventions on behalf of Australia, then the Commonwealth could legislate on matters that would normally have been reserved to the states by the Constitution. Okay. All right. Let's then move on to the second part of this colloquy, and we're going to look now at chapter 3. Let's start then with this idea. So these are the summary chapters you find at the end of every chapter. So for example, for chapter 3, the summary can be found on page 82. Okay? So that's what we're going to just talk about a little bit to make sure that you understand the concept. And of course, you're still responsible for the whole content of that chapter, as well as the lecture recordings that explain it online. So, what is the role of the police and the courts in the legal system? Okay. Key point here is that the police enforces the law, but it doesn't enforce the sanctions. Okay. So you remember the definition we talked about on Monday that said the law has a fourth element where the state is the one that imposes sanctions, but the police doesn't have that role. The police simply enforces the law. So if you are in breach of a law, they can go and charge you, okay, with an offense. They can't find guilt or otherwise. That then has to go to the courts that would administer the law. So they bring in this idea that you have done something wrong. They have enough evidence. Prima facie, on the face of the facts, you have done something wrong. Then it's for the courts to decide whether you actually did something wrong or not, and what you have to be punished with, or what the sentence should be. All right. Hierarchy, we talked about the hierarchy previously. So again, the idea that you have two hierarchies, one of them is from the states, and the other is a federal hierarchy. Okay? So you can see that the highest court in the land is the High Court of Australia, and all of these hierarchies meet at the High Court. Okay? But you'll find things that start, for example, from left to right. You have family court, then that actually appeals to the full court, appellate and superior divisions, or you could start from federal tribunals, okay, like the native title tribunal, and moves up to the federal circuit court and appeals all the way to the full court of the federal court and finally to the High Court of Australia. On the right hand side, at the end of this slide, you'll find that you have a state hierarchy that starts from very simple tribunals. These are things like, for example, the QCAT in Queensland, and then you start moving up to minor courts like magistrates courts, and then district courts, and then the state Supreme Court, the one we have in Brisbane, and then you can go to the full court of that Supreme Court, and finally the High Court of Australia. The difference between these two, when we say the full court, it means that more judges will be sitting on your appeal. Okay, the full bench. So instead, for example, of one judge, you might have 3 judges. Or instead of 3 judges, you might have 7 judges. Okay? All right. So as we said, the High Court of Australia is the highest court. Okay? We have a federal system underneath the HCA, and we talked about the full court of the federal court, then underneath that the federal court, so less judges sitting on your decision, and goes down to family court and federal circuit courts. We talked about the state court system, where the highest court is the Supreme Court, but on top of which you'll also still find the High Court of Australia. In the territories like the ACT and the Northern Territory, the court hierarchy consists of the Court of Appeal, the Supreme Courts, and the local courts. You'd expect that it's going to be less complex than the one that you probably find in the large states. So why do we have this hierarchy? In a nutshell, because of economic and equitable considerations. So the first thing is that it provides a system of appeals. Remember, the higher you go in the hierarchy, the more expensive is your motion. From filing the court fees all the way to moving through the trial process. So we try to go from the bottom up. So if you can solve this question or solve this conflict at a lower system, at a lower court, then you don't have to create a bottleneck at the High Court or the superior courts. So it's a matter of management, or if you like, division of labor. Then you have different forms of hearing according to the gravity of the case. So again, if we are talking about a simple statutory offense, maybe a traffic offense, yeah, there's no reason for you to take that traffic offense all the way to the High Court. You can solve that at a magistrate's court, for example. However, if it's a murder, then because of the severity of the sentence that could come out against the accused, you need to go to more superior courts. If this is a civil case, then it's the same way in relation to the money you're going after. If what you're asking for is a small sum of money, then that could be decided at an inferior court. If you're asking for more, then you will have to go higher up in the hierarchy. Finally, this is an instrument in the building up of precedent. In order for us to have this doctrine of precedent working, so we're talking about binding precedent, we need to make sure that we have a hierarchy where the higher courts can inform the lower courts without having to reinvent the wheel every time we are presented with the same set of facts. If we have decided this previously, then more likely than not, you can use that as a binding precedent to the case at hand. Now, this idea of alternative dispute resolution is going to be our topic for the assignment. So we're going to spend much more time talking about ADRs. But in a nutshell, for our purposes today, we're going to say that there are 3 types of processes, and you can see them as well on page 60 of your course book. So this is going to be the topic for our. But basically, you can see that ADRs are one option of many others. So sometimes there are possibilities to go to certain types of commissions, like the Fair Work Commission, or certain tribunals, like the QCAT, or ombudsmen that relate to certain industries, like the finance industry or the communications industry, or sometimes industry schemes that can also look at challenging, look at solving conflicts. All of these are alternatives to courts. Why would you go there? Because it's mostly cheaper and faster, and in many cases you can actually represent yourself without the need for a lawyer. Our interest in ADRs, so ADRs have 3 different types of categories. And these really depend on the nature of the conflict. One of them is what we call facilitative. So the idea is that either you go and talk to the other party without the intervention of a third party between you. That's what we call negotiation. So there's no third party, it's just the 2 parties to the conflict talking to each other. Or you could have a mediation, which is where you will have a third party, but that third party is neutral. And their role is quite limited. Because all you need from them is to facilitate resolving the conflict. If you want the third party to play a larger role, depending on the type of conflict between the parties, you start moving to advisory roles. So the third party has a certain type of knowledge or skills that they need to use in order for them to find where this conflict should be, or how this conflict should be resolved. There could be conciliation or expert determination. We'll talk about the differences in more details in our discussion of the assignment in the next tutorial, next week. And then you would have something that starts to resemble more and more the judge in a court. So it has more structure and it has more rules. And that's what we call the adjudicative approach, either through adjudication or what we call commercial arbitration. Now you start seeing something that resembles a court more and more, and there are certain rules for example, producing evidence or the idea of what the role of the third party is going to be. Here the third party has more influence on the outcome of the process and not just only the process itself. If you start from the left, you'll find that the parties have more control on the outcome because they can simply say, yeah, I see that there was mediation, but I disagree. And I'm not going to implement what the mediator has suggested or has proposed. Okay, let's just leave that for now here, and we'll talk more about that when it comes to the tutorial next week. All right. Then the idea of the ombudsman. This is a Swedish word that simply says someone who is going to represent you, especially in front of the bureaucracy. Look at the idea of what an ombudsman does. It's simply to investigate, okay, rather than impose any outcomes. The ombudsman wouldn't be able to make any government department or government organization do anything. They simply can investigate and make recommendations. Okay? All right. right, but that's still one way of looking at how you can challenge some of the decisions that come through your way from the government and its agencies. And it's a great advantage because if the alternative is that you have to go and file in the court system and find yourself a good lawyer to represent you, you will really end up with huge costs. But that's not the problem. The problem is that there's this probability of failure. No matter how confident you are in your arguments or your legal position, no matter how good your lawyer is, there will always be this percentage of probability that you're going to fail, i.e. that you will not be able to convince the court or the jury or both that that this case should be decided in your favor. And if that happens, then you might even be liable not only to pay the costs that you have to pay to your counsel, legal representatives, but you also might be liable for the costs of the other party. Of course, if you are a company, okay, if you are a corporation, it's a different story. But if you are an individual, even with things like legal aid, all of that help, I think that it is a very high hurdle to climb. So these other alternative methods would be very attractive in those circumstances, at least as a starting point. Okay, so again, the parties to a legal action are called the plaintiff. This is the guy that moves the action in the court. They bring this action, and then you are the defendant that needs to defend against the charge or against the liability that the other party is arguing against you. We could also talk about the idea of an appellant. We said when you go to appeal, the guy who moves to the higher court is called the appellant, and the other party is now called the respondent. All right. Now there's also distinction between solicitors and barristers. In Australia, it's mostly the split. The split between solicitors and barristers is really observed in Queensland and in New South Wales. There's more fusion in the other jurisdictions in Australia. But basically, as we said in our lecture, in our colloquy in Toowoomba, a solicitor is like your GP, a general practitioner. He's the first point of contact, he or she are the first point of contact if you have a problem. Then you need to go to see a specialist if they find that you really have something serious that needs to go to court. And that's where you would go to the barrister. So barrister, because they are the ones that represent you at the bar. What bar we're talking about? This is the bar that you will find in a court setting, in a courtroom. Okay. So solicitors are really the people that would brief the barristers, but then you will need someone to run this case or the cause of action for you in the court system. So these people are aware of something called procedural rules, and every court has its own procedural rules. Well, there are different procedural rules, so you need to know what's required of you in order, for example, to file this motion and how much you have to pay for that, and then what you have to do in terms, for example, of serving documents on the other party, or things, for example, like discovery and so on. This course will not touch upon any of that, but the key point is that you will need a barrister to do that for you. Although, I should also mention that some people who took this course sent emails after they finished the course and they said, oh, actually I went and used this course to represent myself on the QCAT. Okay? In the QCAT, for example, you don't need someone representing you. Actually, it's usually the plaintiff himself that he or she represents themselves. Why do we have jury? Okay? So the jury are people that are chosen from the community. They are lay persons, so they don't have any specific knowledge of the law, and they simply decide on questions of fact. So, yes, do we have enough evidence that this fact can be admitted or no? Okay? And it's the facts, eventually, that will decide how you argue the case. All right. Let's then go back to our contract and what you need to do. We said this is the structure we will be following in relation to our colloquies and the analysis in the tutorials. And that's what we will be starting on at 3 o'clock after we come back from our second break. So please come back at 3 o'clock where we start on our tutorial.